You can file whatever motion you want, but I'm going to tell you something, sir. I'm not going to sit here listening to frivolous motions.
Well, Judge, as with all SovCits, that's the only kind that he has. Good afternoon and welcome back to Wrangler's Roughnecks. Today we have a SovCit who is making the very ill-advised decision of representing himself pro se in Judge Simpson's court. It's not going to go well. And I've never come across a SovCit this stupid, but at the same time, this calm. Enjoy, folks.
Okay, what are we doing?
To begin, I'd like to just announce a brief summary of the incident that happened.
Pardon?
The incident on October 11th, the reason why I'm here. I would just like to announce a brief summary of what happened.
Yeah, that would be called an opening statement, and it has absolutely no basis or use in a preliminary hearing.
And that's going to get us where?
Well, I did file a motion a couple weeks ago for discovery. I do have a copy of each.
Yeah, no, I saw it. Did you get the discovery?
I did not, but I don't think I properly served it on the prosecutor, so I'm here to do that today.
So what do you want me to do with your case today?
Well, I a few things. I want my bond conditions lifted. I want a discovery. I don't know exactly what the procedures here is. You know that wrongly.
Yeah, I know, because as you're talking and as everything went through, I could tell you didn't know.
Yeah, sorry. But I'm trying my best to do things right.
Well, if you had done things right, you wouldn't have been arrested in the first place. And your best, better yet, a hell of a lot better.
But I just
Okay, you haven't started out well.
Sorry.
You also understand, sir, that there can be great peril in representing yourself. You understand also that at this proceeding and any other further proceeding, that the court is going to hold you to the same standard the court would hold anybody else to. And the court will not play favorites. The court will not help you out. The court will not be assisting you.
In other words, when you ultimately do a piss poor job of representing yourself in court, you won't be able to use ineffectiveness of counsel as a tactic to get out of your punishment.
that process is throughout the whole discovery and trial.
Pardon?
I can be assisted with if I can.
If you request an attorney, so what do we wish to do today?
I would like to first file a request for suppression of this evidence until
Suppression of what evidence?
Of body cams, squad footage.
On what basis would you be doing that?
Miranda versus Arizona.
Well, bud, unless that footage you're asking to be suppressed shows the police eliciting a confession out of you without advising you of your rights, that's not going to happen.
That I was not read my rights prior to being detained, violations that I could have possibly said that could impede my.
That's your basis for the suppression of body cam?
That I have the right to be read my Miranda right. I'm not trying to suppress it from the court to see. I don't want it in the public domain. I don't want it. Anything that happened. I was on the scene. The police were on the scene for 2 minutes. They were dispatched there over a fight.
I don't know what you're going to have to put more in writing for me to even understand that, because as it stands here right now, based upon what you told me, I'm going to deny your motion.
Deny my motion to suppress under Miranda.
As you're calling it, your motion's denied.
Maybe I'll formulate my request a little more precise to my specific conditions, but I also am requesting that there's full discovery in this process.
Okay. Have you sent a request to the prosecutor's office for discovery?
I have not. Nope.
So you want the judge to make the prosecutor do something that you have yet to even ask them to do.
Had you asked them, how do I get discovery?
No, I will be doing that.
Did you ask anybody how to get discovery?
I asked a couple of the clerks, but they can't, give too much legal advice. So I'm trying to take as much responsibility for this as I can.
Okay. Well, I'm going to at this point, deny that motion because there hasn't even been a request for discovery. If you don't get something, then you bring a motion for discovery.
Okay.
Next thing you want to do.
Discontinue all hearings until there's substantial evidence on file.
Okay, that doesn't happen now.
So you want the judge to postpone your case until you feel that the prosecution has enough evidence.
I don't know what discontinue all hearings mean.
I don't know either, Your Honor. I'm just representing myself over here.
This is going to be a long process if you just are throwing stuff out there.
I tried to prepare my best for this.
Try going to law school.
I'm really
Okay. This was your best.
I'm
Then
not
you may
looking.
want to consider getting an attorney, but I'm going to let you go because you have a constitutional right to do it. But this is going to be a long, arduous process if we're going to go at this rate.
What does the prosecution expect next in this case?
Pardon? What do you mean?
You're asking me for what I want out of this case and what I expect.
I'm asking you, what do you want to do today?
I want to go home and have all charges lifted.
Not gonna happen. No, not gonna happen. Not.
That's not going to happen.
Okay, so
I mean,
what do I got to
going
do
home
to
is
get?
an option, but the charges aren't going anywhere.
I understand, and that's the end goal of where I want to be one day.
What do you want to do, sir?
All right. Well, the judge took a recess and gave the defendant here a couple of hours to figure out, whether he's going to pull his head out of his ass or not. And so let's see how he does in round two.
Does the court want me to go through each one and then make a ruling on all, or do you want to do one at a time?
Let's do one at a time.
Okay.
All right. You got any response to the people's response?
Not for that, Your Honor.
No. Motion denied.
Thank you. The second request is request for discovery, where the defendant appears to be requesting that we produce different discovery items, as well as there's a sentence here that says the defendant possesses exculpatory video footage. Request an opportunity to submit it for review. If he wants to give us something, that's fine, but I just think he should go through the normal discovery process, and I'm not saying the court not order what he's requesting in number two, because it doesn't appear that there's been any request filed for discovery that hasn't been fulfilled or completed at all.
That portion of the motion also, when he submits his request for discovery, then I'm going to deny that one specifically without prejudice. That way he can raise whatever issue he may have.
All right. Well, apparently the defendant has not even yet asked the prosecution to give him the discoverable evidence, but he's making a motion to the court to compel them to do something he hasn't asked them to do. Maybe if he had just asked the prosecution to give him the discovery he's asking for, he wouldn't have had to make a motion.
I agree completely, Art. Thank you so much. Number three was particularly troubling to the people, as it appears to be a request for the people to get medical records for some person and give those to defendant. I responded that request was unclear, but it appears to be that the people executed a search warrant to obtain medical information for an alleged witness who does not appear to be mentioned in the police report currently in possession of the people. Unless otherwise directed by the court, the people would think that people do not intend to execute a search warrant to seek out private and potentially privileged medical information for this person.
Your Honor, in response to that, I have a FOIA records describing the witness and his shirt that he was wearing, which is the reason why the deputies or the detectives were dispatched to the Puffer Reds parking lot.
See if I understand this correctly. Because a witness was wearing a t-shirt in a parking lot, you want the court to give you his medical records, which are private and legally protected from prying eyes? Interesting.
At 3 a.m. that morning. I also have a picture of the witness being right there when I got arrested. I can show you it. It's quickly available here for me to show you, but he's really within.
I really would be
grasp.
And again, what does that have to do with the court giving you this gentleman's medical records?
So given that I do have FOIA on my CAD records for the dispatch record of police when they made comments saying there's a Huron Valley ambulance dispatched for a person due to high intoxicants.
And again, what does that have to do with you obstructing and resisting arrest?
I wasn't dispatched through Huron Valley, but this is in my police report. I think this is valid enough to say that he is a part of the same scenery and event.
Do you have a name?
His name is, I've known him for 15 years. I was with him throughout the course of the night and
So you want his medical records?
I want to, first of all, subpoena him to get his witness statement on record officially. And I would also like his records due to the nature of why they.
I'm not going to order. I mean, that is, I'm not going to order medical records. If you tailor a request for something that isn't available in another fashion, then that's fine, but I'm going to deny that.
Yeah, a lot of my civil procedures, I will be correcting and will not have any more problems with. But as for right now,
Your civil procedures?
I'm trying to follow the rules of federal civil procedures, and this is my
Of federal?
You're in a state criminal court, you freaking crackhead. What does the guy's medical records have to do with the Freedom of Information Act? And again, why are you trying to use the rules of federal civil procedure in a state criminal court? Get an attorney, dude.
Oh, yeah, this is,
Yeah.
I think so.
Okay, so we're a state court,
Okay.
and this
I'll
is
try to
criminal
follow state
proceeding.
ways then. Thank you for
So-
your guidance.
Yeah, so you might want to start there.
Okay.
Okay,
So that 3 is denied.
huh?
3 is denied, Your Honor.
The whole motion's denied, yes,
Thank you.
all three parts.
Number 4 was to subpoena a witness. I just responded that the defendant should follow the subpoena process that's available to him.
You're filing a motion to try to file a subpoena?
The defendant is requesting the court produce all audio or video recordings. I said he should go through the discovery process. That's that motion at this point,
It's denied.
thank you.
You can
Number
give it
6,
to him.
the people, I'm not exactly sure, there's a motion to seal statements?
I don't know what that meant.
I don't either.
What does that mean?
It means any statements that I made under stress to either the police officers when they were questioning me or before, after.
What do you want to do with them?
Hinder my trial experience as I was not
What does that mean?
I was not given proper notice of my rights when I was detained, and I was questioned thoroughly
So you
afterwards.
have to file a motion, you'd have to lay out specifics as to how and or another, any statement that you made.
My response to number 7, which is the defendant is notifying the court of exculpatory video evidence. Any response to that? Really beyond the fact that it seems that these are videos the defendant has and that he hasn't received any videos from my office yet. So I don't see how.
So it seems that the defendant wants to suppress the videos he made.
I have videos, both FOIA requested from the Ypsilanti Police Department and my own. I was formalizing the process for the prosecutor to build her prosecution.
To do what?
When I requested discovery items that I'm going to do following the rules of civil procedure.
This last one, what are you going to do with that? What do you want the court to do?
I want the court to find on what grounds throughout the discovery process that I'm guilty of these crimes.
The court is not going to use the discovery process to determine your guilt. They will use the evidence presented at trial to ultimately determine your guilt.
Okay, sir, it doesn't, you seem to want this process to work away. It doesn't.
Maybe that's a disadvantage of being pro se.
Yes, there are huge disadvantages because I think you know what you're doing, but you don't. It's become readily clear to me. You have no idea what you're doing.
Well, all due respect, Your Honor, Helen Keller could have told you that.
Motion denied.
Number 8, defendant requests the court cancel all current bond conditions pending the.
Motion denied.
Thank you. Motion to continue proceedings. People weren't opposed to adjournments, but this is actually kind of includes several things. The request is to continue all scheduled hearings until requested testimony, evidence, and hospital records are provided. So I don't have an issue if the defendant needs more time to be prepared to have hearing, but I do have an issue if he's trying to say that he can't do anything until we get somebody's medical records. So I'm going to get a search warrant for somebody's medical records and depose officers in a criminal case.
Which both of those have been denied. So by default, that would have to be denied if that's what he's asking.
I've made a note of the new address mentioned in section 10, and then there's number 11 is to seal all indictments. I don't know what this means.
Seal all indictments. Yeah, I've never heard of that either.
I don't know.
All incident related documents and evidence. I don't know what that means.
What does that mean?
It's reiterating the sealing. Anything that I said is really.
I don't know how that sealing would take place.
Okay.
I think you really need to think about getting an attorney. That part of the motion is also denied.
That's all. Thank you, Aaron.
Okay, so what are we going to do?
Well, I would like a chance to amend the motion.
No, you can file whatever motion you want, but I'm going to tell you something, sir. I'm not going to sit here listening to frivolous motions.
Okay.
I'm just not going to do it. 3/4, if not 7/8 of that motion that we just dealt with was frivolous.
Well, Your Honor, since you just denied 8 motions, I think 8/8 were frivolous.
So what do you wish to do now? Do you wish to have a preliminary exam set?
Yeah, I'd ask for some for adjournment in order to review the discovery materials I've produced.
No.
You want an adjournment to review the discovery materials you produced? Wow.
From my FOIA
That what?
that I've came up with through my FOIA request. Or I'm going to plan on submitting the procedures as normal through the prosecution too, as well. But I need time to review the
What does
documents.
that mean?
That means I just got the documents and I haven't been able to review them, and I need time to review them. Your Honor. I can't decide on something and request for something right now in this moment if I haven't reviewed.
So all you want is an adjournment.
After this response that I submitted to her and she submitted back, adjournment for pretrial, adjournment for discovery materials.
You know something, sir? Just because you use what seem to be legal words and try to place them into a sentence doesn't mean that it makes sense.
I understand that.
That'd be the first damn thing you understood today.
No, I don't think you do. I think you were just placing words in sentences, thinking that because what you're asking for makes no sense.
True, Your Honor, but it makes for damn good content.
And if you think it does make sense, then maybe this court needs to send you for a competency. And I'm not saying that jokingly. I'll grant your adjournment. Next time you'll need to fill out a sheet to do it, but I'm not going to waste the time today to do it.
Thank you, Your Honor.
And Your Honor, for the record, I put the email address the defendant should contact for discovery on this post-it note, which I'm going to place here, and he can pick up. He's indicated he doesn't want to communicate with me about.
He doesn't want?
Oh, at
He
that
doesn't want to
moment.
communicate with me about his case earlier, so I'm not going to speak with him today about this case. But I've given him the post-it note to get discovery.
Oh, yeah, that's a good way to get this going. All right. Probable cause conference,
Thank you.
2024, 9 a.m.
And if possible, I will try to find more on about this guy, because this is too priceless. I've never seen SovCit and passive aggressive combined into a bastard child like this. This is just absolutely ridiculous. But anyway, it's Wrangler. I'm out of here. I love y'all. Have a good one.